Okay. This stuff looks fine for this.
What's that?
I'm looking at this stuff for the objections if you want to send that out to everybody.
I'll start drafting the call today because it's too late to do it today.
Yeah, that's okay. Are we ready?
Yes.
All right, we're just waiting. We're just waiting for everybody to connect here, guys. And we're just waiting for Mr. Prince to have audio. And he does not yet have audio. All right, good afternoon, everybody. I am referee Brian Nicholas with the Macomb County Family Court. I'm here today actually on the case of Peters versus Zaya, case number 2022-0773DS. And guys, just as an aside, Mr. Peters and Miss Prince, you guys were before this referee back on August 28, 2023, at which time, Mr. Prince, you filed the present DP action, and at that time I dismissed it, indicating you needed to file this action under the DS case between Miss Peters and Mr. Zaya. You again have filed this motion under this case. Is there a reason you filed it under this case and not Miss Peters and Mr. Zaya's DS case?
Well, when I went to the court, they were still instructing me that I couldn't file under the DS case. So
who told you that? Who told you that?
One of the clerks
at the courthouse or here at the front of the court?
No, at the courthouse. I haven't been to the front of the court.
Yeah, I don't know why the clerk's office is making legal determinations, because I would disagree with them. But I'm going to view it as filed under the DS case to be a third party intervener under that case, because I do not believe it should be brought as a separate paternity action. I think it should be brought as an action with the DS, but I'm going to indicate that it's to be viewed as a motion for revocation under the previous DS case. And I know, guys, that's confusing because you're getting told one thing by the clerks and I'm telling you another. But I just want to make clear, because there's an established custody, parenting time, and support on the DS case between Miss Peters and Mr. Zaya, this is properly under that case, because you're intervening as a third party saying, I want Mr. Zaya's established paternity revoked. So I will respectfully disagree with the clerk's office, and I'll take this up for them. But before we continue, sir, I'm going to have everyone state their names. And again, Mr. Prince, your name for the record?
Shante is Prince.
All right. And Miss Peters, your name for the record? And ma'am, you're muted right now.
Oh, I'm sorry. Courtney Peters.
Okay. And Mr. Zaya, your name for the record?
Kevin Zia.
Or Zia, I'm sorry, sir, about mispronouncing your name. Okay. So guys, I want to just procedurally go over what has occurred. So on August 28, 2023, Mr. Prince and Miss Peters appeared before this referee, sir, on the same action. You filed a paternity action under Macomb case number 2023-3435 DP, asserting you were the biological parent of minor child Chloe, and Chloe is 2. Is that correct?
Yes.
Correct.
All right. And however, there is a previous support case, and on August 30th, 2022, a judgment of support was entered between Miss Peters as the plaintiff and Mr. Zaya as the defendant, finding him to be the father, giving him custody and parenting time rights, and ordered him to pay Miss Peters support. So paternity has been established of Chloe. Now, the testimony is that Mr. Prince and Miss Peters took a DNA test, and in fact, Mr. Zaya is not Zia, I'm sorry if I'm mispronouncing, is not the biological parent. Mr. Prince, you are. And does everyone acknowledge that the DNA tests show that Mr. Prince is the bio parent?
Yeah.
Or is that not agreed to? Okay. All right. So here's the interesting thing. So I'm going to have just a kind of a heart to heart with everybody here, kind of where you're at. So the Revocation of Parenting Time Act, or I'm not Parenting Time, Revocation of Paternity Act allows Mr. Prince as the bio dad, because you acknowledge he is Chloe's biological parent. If she is under 3 years of age, he can bring an action and say, I want a hearing. I want to be established as the parent, and revoke Mr. Zaya's paternity or his establishment as the legal parent. The rough thing is the court says that there has to be an evidentiary hearing for everybody to submit witnesses and evidence of whether the court feels it's in the best interest to revoke Mr. Zaya's paternity of Chloe, because he's not the bio dad. We all acknowledge that. You guys acknowledge that, and give Mr. Prince rights to custody and parenting time. So here's the reality. You guys have a right to that hearing, and I'm going to refer it for that hearing today. But this is the reality of what you guys have to think about. You will have to show that Mr. Prince, if for some reason it's in Chloe's best interest that he have no rights, and that Mr. Zia remain established as the legal father, even though he's not biological. Under the support judgment, he's deemed the dad, he's a legal dad, and for some reason, Mr. Prince should be denied that right, even though he's the bio dad. Probably going to be a hard argument to make to the court to prevent him from having any kind of rights. But it puts you guys in a rough situation because Mr. Zia, you're with Miss Peters and you've been raising Chloe as yours. Is that correct?
Yes.
All right. And even though you're not her bio dad, you would like to remain her legal parent and have the rights as a parent to her.
Yes.
Even knowing that Mr. Prince is her dad.
Yes.
So let me ask this. So Miss Peters, how do you see what would be your perfect outcome, not taking into consideration what the law may or may not say? What would be your perfect outcome in this situation going forward with Chloe, Mr. Prince, and Mr. Zia?
Going forward, I would want Kevin Zia to remain the legal father and have rights of Chloe. During that time from December to April, Mr. Prince has showed concerns on my behalf of just not being a present father. Like when I would ask him things, when Chloe is in his presence, he feels that it's an issue. I shouldn't ask questions. As far as simple questions like, oh, what does she eat? We just couldn't see eye to eye on things. And me and his sister has had some issues as well. And ever since December, it has always been issues. It's been drama. It has brought drama into our household, our relationship dealing with Mr. Prince and his family. And at this time,
why did you tell Mr. Prince he was the bio dad and have this DNA test? Why did you guys do that?
I reached out to him on Facebook Messenger and asked him if he could take a DNA test. I don't know why.
She didn't look mixed.
Because she didn't look mixed. That's the reason why. Why is it not?
Okay. And you can still hear me, ma'am?
Yes.
So guys, I think we all acknowledge this is a complicated situation. But the reality is here, I will refer this for a hearing, but the hearing is going to be that, Ms. Peters, it's going to fall on you to argue in Mr. Zia that somehow it is against Chloe's best interest to recognize her bio dad. And give him rights. That's probably going to be tough, but I'm going to refer this for that hearing. You have a right to that hearing and to argue that it's not her best interest to revoke Mr. Zia's paternity and establish Mr. Prince. In the meantime, that hearing is not going to come up for probably 6 weeks or so. You guys are welcome to keep talking, brainstorming on what you think would be a good resolution of this. And we will then
sir, am I
for
able
the
to
hearing.
speak?
Go ahead. Yeah, go ahead.
So it's definitely always two sides to a story. I did not know that I had a 2-year-old daughter until December. And now that I know I have a 2-year-old daughter, Ms. Peters is upset with me because I won't do what she say. I won't be in a relationship with her. She's told me countless times how she doesn't want to be with Mr. Zaya. She wants to be with me, about all the domestic issues that they're having, all the substance abuse issues that he's having. How would I know all of this? Because Ms. Peters has told me. And since she can't dictate my life and how I parent my child, she takes her away from me. Anytime I don't do what she says, and once again, why
Well,
would
how often were you seeing Chloe?
I was seeing her every week since December.
And
I
and
haven't
you were
seen
seeing
her
for an
since April.
afternoon, a day, or was that for hours? Was that an afternoon? That was a day.
Mornings and evenings. And then I would drop her off late evening. I haven't seen my daughter in
Okay.
5 months. 5 months.
Okay.
She thinks that this is I don't know if she thinks this is a joke. This is a life that we're dealing with. At this point, she doesn't want me to have rights. Why? This is my child. This is my bloodline.
Okay.
This is not a joke. So I'm here fighting for my child. And they are trying to take my child away from me and don't want me to be a part of my child's life. How is that fair? Because we're having a disagreement.
Okay. So you made your
my child's life.
Okay. You
forever?
made your point, guys. Guys, listen. You made your
fair?
arguments.
I'm just asking a question. Is that fair?
Stop. I said stop. When I say stop, stop. You've made your argument. I've made the point at the beginning of this hearing about the legal reality of this situation. You've made your argument. You're saying you think it's in your child's best interest, in so many words, not using those words, that you have a right as a father, and that whatever inaction
At this point,
she
I'm fearing
alleges,
for my child's life.
you're fearing for your child's life. Why?
Yes, because of what Ms. Peters have told me about the
Did you?
substance
Well, have you
without
called
the-
child protective? Have you called child protective services or law
Yes,
enforcement?
I spoke to them.
And
Yes.
what did they do? And what did they do?
They went by. They did a wellness check. Definitely.
Okay, so
That
and
was
they didn't
CPS.
issue
No.
They sent
That was
the
the police.
St. Clair
Guys,
Shores police over
Oh
here.
my goodness!
Guys,
Once again,
guys.
so I can't have rights to my child.
Sir,
I can't be in my
guys,
child's
bring it
life.
down. Bring it down. I know everybody's passionate. This is a court of law. Bring the
No one
tone
is in my
down.
shoes. No one is in my
Mr.
shoes.
Prince, Mr. Prince, stop yelling at me, or in the future, you guys are going to come in person. I'm not going to give you the ability to be remote
I
and
would
yell
rather
and
come in
scream.
person.
I can listen to you at a calm level.
Okay, I would
Court
rather
tends
come
to
in
be
person.
court tends to be passionate, but guys, this is a court of law. Whether you think someone's good, bad, a liar, a criminal, you don't get to yell and scream in a courtroom. I can listen to you be calm. I get that you're passionate. I get you say you are the bio parent. I know you're the bio parent. You are frustrated that suddenly you say you've been denied. I get it,
No
but you
one
don't get to
cares.
yell at. I'm just going to stop. Anything else you want to say?
Go ahead.
All right. So I'm going to make my recommendation. You both have 21 days to object. We have this tug of war. So I'm going to consult with the clerk's office of why they keep refusing to let you file under the case that I say you're supposed to file under, and I'm going to resolve that issue. So as far as this motion today, and I take it nobody objected to the August 28th order that it's going to dismiss this case. Making that for a no. All right, so I'm going to do a brief statement of facts again and see if we can get this to where it needs to be. All right. All right. On August 30th, 2022, a default judgment of support was entered between plaintiff Rihanna Peters and defendant Kevin Zia. pursuant to Macomb case number 2022-0773 assigned to the Honorable Tracy A. Yokich. Pursuant to that judgment, plaintiff Ms. Peters and defendant Mr. Zaya were awarded joint legal custody of minor child Chloe.
Wow, this is something.
And Chloe is currently age 2, is that correct?
Yes.
All right, currently age 2, with physical custody being awarded to plaintiff. Defendant Mr. Zia was awarded reasonable rights to parenting time in order to pay child support. New paragraph. On August 28th, 2023, plaintiff Shantez Prince and defendant Courtney Peters appeared at motion hearing pursuant to case number 2023-3435-DP on plaintiff's request for custody of the parties, for establishment of paternity, custody, and parenting time of minor child Chloe. At that time, both Mr. Prince and Ms. Peters acknowledged that a DNA test has established that Shantez Prince is the biological parent of Chloe by 99.999% probability. New paragraph. On August 28, 2023, an order entered, or I'm sorry, recommended order entered that the DP action should be dismissed as pursuant to the Revocation of Paternity Act, MCL 722.1443. If an action for support, custody, or parenting time exists, an action under this act shall be brought in the instant case. As such, Mr. Prince was directed to file an appropriate action within the DS matter. New paragraph. Parties return for motion hearing on today's date on the DP action. Kevin Arzaya also appeared. Mr. Prince alleged that the clerk's office would not permit him to file within the DS action and advised that he again should file a motion in the DP action. New paragraph. This referee will deem the motion filed in a DP action as a motion to intervene in the DS action under the Revocation of Paternity Act. New paragraph. As such, it is again recommended that the DP action be dismissed and this matter proceed under the previous DS action between Ms. Peters and Mr. Zaya. New paragraph. The matter of Mr. Prince's request to revoke paternity of minor child Chloe with Mr. Zaya as referred for a referee evidentiary hearing as to whether that is in the best interest of Chloe. Ms. Peters and Mr. Zaya testified that they do not believe it is in Chloe's best interest to establish paternity and bio father and object to the revocation of Mr. Zaya paternity of Chloe, although he acknowledges he is not her bio parent. Did we put that as a record? How did I just put it?
I'm open, it's fine.
Okay.
Okay.
So guys, I'm going to make this a recommended order with 21 days to object. I'm not going to adopt it as an order. I'm going to make sure that both judges Jokic and Dennings are competent and feel comfortable with this order. You both have 21 days to object. Should either one of those judges want this order amended, you will receive a copy of it as well as additional objection period. So again, I'm going to say that this should have been brought under the DS case. I'm going to view this motion as a motion to intervene in the DS case rather than a motion under the DP case, and refer this for evidentiary hearing, which is a hearing to present witnesses, evidence, and testimony, ma'am, for you basically to prove or try to tell the court that is not in Chloe's best interest to establish parenting time and custody in her bio father and revoke Mr. Zaya's paternity. Your arguments today, guys, are a little hint at what is going to be presented at that hearing. So you guys have to decide if there's any avenue that you guys, the three of you, can reach a consent agreement. If you can, that's great. If not, but that's the sense of what's going to be presented at this hearing, either just through the three of you or through your witnesses and testimony. But ma'am, it's going to be basically more or less your burden to show that it's in Chloe's best interest that her bio dad not have parenting time rights or that Mr. Zaya's paternity get revoked. It's going to be tough. I'm not going to lie. It's going to be tough. And Mr. Zaya, go ahead. See ya.
What was that you said if we could come to some type of, what was that, agreement or something?
Yeah, so on that date, if you guys come in, so for instance, you could say, we thought about it, Chloe's young. We agree that Mr. Zaya be revoked. At that point, that would terminate your support obligation. You would no longer be the legal dad and we'd establish Mr. Prince, and then we'd open the door for a new support action with Mr. Prince.
Oh, okay, thank you.
But so you guys have to think about what you want to happen. I'm going to make sure that the judges are comfortable with me consolidating this in the DS and not leaving the DP going. If they have a different sense of what we should do, then we'll send you'll get another copy of the new order with an objection procedure. But I'm going to talk to the clerk's office and the judges and clear this up as to how they want this under the DP or DS. I believe it should be under the DS, but we'll see. If the judges say leave it under the DP, we'll do so, and I'll amend this order and you guys will get another copy. Okay. All right. So guys, I'm going to send everybody, and Mr. Zia, do we have an email address for you?
I'm not sure.
Do you mind giving us one just so we have one? Because I want you to get notice of all these proceedings too.
All lowercase letters.
Okay, and I'm just going to indicate at the top of this order is going to be Ms. Peters and Mr. Zia. And then with defendant as an intervening third party. And then I'm gonna put that, Mr. Zia should be notified and served with all pleadings and motions in this matter. All right, and guys, we will email everybody a copy of this order and objection procedure by the end of the day today or early tomorrow. And you guys both everyone has 21 days to object, okay? All right, guys, have a good day, everybody. That's gonna conclude this hearing.